What are we doing today?
Your Honor, this is a bond hearing. I'm stepping in for Mr. Smith. He had an operation on medical procedure last week. This is reset from previous.
This is not just another routine courtroom docket. This is a pressure cooker of legal consequences, delayed evidence, and high-stakes decisions that could change lives permanently. A defendant sits in jail waiting on blood test results that may determine his freedom, while the judge openly questions whether giving him probation was a mistake in the first place. From bond arguments and GPS monitoring to admissions of guilt in serious felony cases involving children, this courtroom session moves fast, and the consequences are heavy. Pay close attention, because what unfolds here isn't just legal procedure. It's accountability, discretion, and justice colliding in real time.
Bond hearing, UWI, in the way there has been no blood results yet. My understanding was the last court hearing, we wanted to, I guess there's something mentioned in reference to December 1st, to get the results, so you will want to go back and revisit possible bond conditions so that he may be released. And I do have argument in reference to.
Go ahead, argue.
He has been sitting in jail since this arrest. We believe that there are conditions that could be satisfied. Mr. Hubert has strong family ties, which I believe were talked about in front of this court before. He also has strong church ties with Reverend Adolph in this matter. He is asking that he be released. He has no objection to either GPS or home confinement. He has no objection to possibly a monitor placed on him in reference to alcohol. He just does not want to be sitting in jail waiting to see if what the results might be. I believe most of the other things he has complied with probation, except for this offense. And he would like to start back to try to start continuing pay his restitution. So we ask that you consider.
How's he paying his restitution? How is he?
All right, I mean, I'm talking about his fines and food, fines and.
Oh, okay.
I'm sorry.
How's he doing that?
Well, he's not doing it sitting there.
No, I understand.
But he's got family that has, my understanding is he's got family that he was, they were going to start back and catch up on whatever he is.
Family's going to pay?
No, I have a job working
Where?
at William Brothers Construction. And I
How
also
much do you make an hour?
I make $18 an hour, so I also play the drums at Antioch, where I get $1,500.
You do what there?
Play the drums.
At church, at Antioch Church. So he'll be going back and forth to church or staying at home and the court. He will not be driving. Do you have a way of
My
not?
pastor said he will make sure I get back and forth from home from work.
You will not drive an automobile.
Can't allow his license.
What's the status on the blood? When is that every
Talked to them this morning. All the preliminary tests are done. They have to have it reviewed. The earliest that the results will be is Wednesday of next week. More likely it'll take 2 weeks, but we'll have it before the first of the year.
Okay.
And Judge, we've
But we
been,
won't have a hearing before the first. We'll have to have it after the one day, but I presume.
I've been pushing to
All
get,
next week. We're looking all next week, aren't we, on stuff?
next week. No, Your Honor.
No, we're done next week.
I will, as soon as I get the results in, I'm going to forward it to whatever attorney of record is. I know that
It's not.
Tom's showing up for Bruce, but Judge, you've heard these same arguments from Mr. Faggard, from Mr. Smith. You have been asking me to get the blood test results, and I've worked diligently to try to do that. There are a lot of factors that are out of control. This is as quickly as we can do it. It has nothing to do with trying to keep Mr. Joubert where he is, but we were also not with him whenever this alleged offense occurred on August 30th. We all want to know what the blood test results are before we do anything.
So we're gonna have a hearing set like in the second week of January. Is that, yeah, I mean, y'all are ready to go, right?
We're ready, Judge.
Okay.
I would only ask that possibly that you would set something and let him determine, or his family determine whether or not they want to spend the money for either that short period of time or wait till.
It was, but it's
Judge, you know what my position is about that.
$10,000, Bob.
Judge, we have stated let me clarify then on the record. You have stood with me about the argument that I've made in the past. I made a mistake placing this man on probation. I went out on a limb, gave him an opportunity based upon all the arguments that you're hearing here. When you look at his PSI, you see that he did not qualify for the probation that was given to him as far as getting it from a jury. And here we are.
But he got it.
He got
He
it.
got it.
And now
How was that?
I look really
What?
bad in making that decision.
No.
And I don't agree with setting a bond on one that he is not entitled to it by law. It is the court's discretion.
It's the court's discretion. He isn't, they're all.
He isn't entitled to it by law. You can,
So
yes,
the
sir.
court's going to set one and violate a law?
No, sir. No, sir.
Okay.
No, it's discretionary with the court.
Clear. Yes, it is.
It is.
I believe you also going to make the condition of home confinement.
I'm sorry. Yes. Bond's $10,000. You have to have a GPS device. You must be in home confinement. You cannot leave the house except to go to the hospital. You understand? Are you going to be living with your family?
Oh, yes, sir.
Okay. Let them go out back and forth and take care of things. But you're going to stay in home confinement. We're going to set this for a hearing on the second week in January. That's all. No.
I mean, all we have is this dull pair of sisters and that thing is, they're called, it isn't so from brain up. And Chris was talking about that after.
We have three cases involving Ronald Lee Tyler. Is that you, sir?
Yes, sir.
Present with Mr. Gertz, your attorney and the state's attorney. Our plan is he's going to be pleading to 2 and 1 to be dismissed. Which
Yes.
one to be dismissed?
The one ending in 4-5, Judge.
Okay, 38245 to be dismissed. So the defendant will be pleading to 2 cases, which are called 21-38243 and 38244. Does the defendant waive formal readings of these indictments and arraignments? Can we proceed in summary?
He will and we can, Judge.
In summary, sir, each of these indictments similarly allege that on or about August 19th, 2018 in Jefferson County, Texas, you committed the second-degree felony in each case of indecency with a child involving 2 different children. Do you understand what you are charged with here, sir?
Yes, Your Honor.
Each of these cases are second-degree felonies. Can't get into the box in this program.
You make me crazy doing it. Every time I touch the sides or something, stuff's popping up. And
Each of these cases, sir, are second-degree felonies, which mean in each case, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, Your Honor.
I just wrote my name and then it erased immediately. So an agreement has been reached in these cases where whatever punishment shall not exceed a cap of 10 years imprisonment. This is for each case.
yes, Judge.
And are these sentenced to run concurrently
Yes.
as part of the agreement?
Yes, sir.
Okay, let me add them. And clause number 38245 will be dismissed as a part of this agreement. And also for 21-38244, in that case, a similar agreement has been reached by the parties where you would be pleading guilty. Whatever sentence shall not exceed a cap of 10 years imprisonment, which will run concurrently with the other case you are pleading guilty to. And those will be accomplished at the same time. What we're going to end up doing is accepting your pleas today and then postponing sentencing until a pre-sentence report is prepared from the probation office. We will all return back, add any additional information necessary, and then the court will make its decision on the sentence. Do you understand the plan?
Yes, Your Honor.
If I follow this agreement, sir, you have no right of appeal of your case in each case situation. Do you understand?
Yes, Your Honor.
How do you plead in each of these cases to these indictments in 38243 and 38244, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, Your Honor.
Let me show you here in each case what's marked as State's Exhibit 1. Did you sign those documents voluntarily?
Yes, Your Honor.
Understand them, discuss them with your attorney, or the contents alter and correct?
Yes, Your Honor.
State's Exhibit 1 is tendered into evidence in each case.
We have no objection, Judge.
Without objection, it will be admitted. Among other things, this states you are mentally competent to enter your guilty plea in each case. It's freely and voluntarily made in each case. You understand and appreciate the consequences of pleading guilty. There's sufficient there is sufficient evidence here supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. Do you understand?
Yes, Your Honor.
And you are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. And you are totally satisfied with the representation provided by your attorney in each of these cases. And this says this is all true. So help you God.
Yes, Your Honor.
State's Exhibit 1 will be made a part of the record in each case without objection.
No objection.
All right, what we're going to do is order a pre-sentence report in these cases, and we will return back. After that is accomplished, we will return back. When is our next setting?
You can do either January 29th or the 30th, the Thursday or Friday.
We should probably do Friday. I'm going to be in the capital trial in Houston.
All right, Friday.
So Friday.
Okay.
On what's
I'll
the
let you
date
know if
again?
that goes long. It shouldn't,
Yeah.
but
We can always move it if need be.
thank you.
So, do you understand in each of these cases, sir, you are looking here are your options. You could be sentenced to prison for a term of no less than 2, no more than 10 years confinement. You could be placed on deferred or unadjudicated probation in each case where you are not found guilty and placed on a form of probation. And then I think regular probation is not an option in these cases by law. Isn't that the understanding? So those are your only two options here, and your attorney will be able to discuss with you the ramifications of each of those. And so also you will have to register as a sex offender. I don't think that has to be done today. It's when you
It can be done
are,
in sentencing.
it's when you are sentenced.
And Judge,
But
I've
that
discussed.
has consequences to it
Yes, sir.
that your attorney has gone over with you. When we go over that at the time of sentencing, there will be a document and I'm going to review with you what the consequences are and what your requirements are for registering regularly. Failing to register properly under the law can result in a criminal act that you could be prosecuted for. So those are some consequences and requirements and responsibilities that you're going to have to deal with because of this matter. All right, we've reset it until what day?
Tentatively January 30th.
Okay. January 3rd, 26. Try to get used to that. Also on that day, if all of this is done, the court will sentence you, and then this other case, 38245, will be dismissed as part of this agreement. Anything else?
No, Judge.
That is all. Are you Taylor Neville? And you were charged here with the state jail felony of injury to a disabled individual, which carries with it up to 2 years in the state jail. Mr. Dusler was appointed to represent you. Have you actually hired?
Yes, I hired Marcus Wilkerson.
Hold on. I'll speak. I'll end my sentence and then you can speak. Don't interrupt, okay?
Yes, sir.
Have you hired Mr. Wilkerson to be retained as your attorney?
Yes, sir.
All right. Then he's not here though, right? Okay. All right, what we're going to do is set this for an announcement and we'll get the message over to him, but it will be an announcement. What's the thing?
6 weeks.
6 weeks. Get a resetting. Willie Hugh. That lady.
He's in custody and it's not been brought back yet. As soon as he gets here.
Your Honor, Mr. Shoemade is currently.
Well, this is 24 CR 901 and you will be on Showman.
Yes, sir.
Okay, with your attorney, Mr. Johnson, and the state's attorney. Go ahead.
Judge, Mr. Shoemade is currently in a residential facility run by the Veterans Administration Rehabilitation. They gave him permission to come here to court today. I've spoken with the state and I'm going to be applying for their Veterans Court program. I think he's an excellent candidate. He has no history besides this. And I think he'd be an excellent candidate.
Why is this taking so long? I mean, we've been dealing with this for a year and a half now.
I haven't been on the case that long. I've done
Yeah, back in May is when you were arraigned of 2024. And then somebody was appointed to represent you. It looks like Langston Adams, maybe, back in June of 24. Man, that's a year and a half, and we hadn't gotten a darn thing done. Well, that's not right on my watch. That's not. We moved forward. How long is this going to take?
Judge,
Not another year and a half.
No, Judge. As I said, he's currently in residential with the Veterans Administration, and I'm pretty sure that the state can make a decision about their veterans program pretty quickly.
We'll just have to turn over the paperwork and have it reviewed by who runs the Veterans Court in our office.
I'm going to reset it for how long, do you think? What do y'all think? I don't know what y'all's timetables.
4 weeks.
4 weeks, okay. All right, let's see what we can do about that. Huh? Yes, you've got with Colby Washington too, right?
I do, Judge.
Okay. This is going to be, who is the state's attorney on this? Mr. Ham? You are with Colby Washington. You got 2 second-degree felonies of sexual assault of a child. That's up to 20 years on each case. Second degree felony of online solicitation, and that's another up to 20 years. And illegal possession of child pornography up to 10 years. Hello. We're talking about you're exposed to up to 70 years in prison on all of this. Serious. 4 serious cases. All right. Today, what are we going to do?
Your Honor, I have speaking to the state, conveying an offer of Mr. Washington, they indicated that he does not wish to take their offer.
All right, set it for trial. Which case you want to go on first?
I don't want to make that decision today, Judge.
Okay. We've got 4 of these, and we'll just do one at a time. I guess one of the second degree felonies, I presume.
Yeah, and I may try all of them together. I do intend to file a motion to consolidate. That's why I'm not prepared to make a decision about which one I'm moving forward on first.
The state has been doing.
All right, we'll set it for trial. When can y'all be ready? Because these are fast tracked when they're involving.
I'll work as diligently as I need to, Judge.
Yeah. Okay. It's going to get fast tracked. Just get ready.
Yes, sir.
And we'll try these as soon as possible. I have Terrence Killingsworth. Yes, sir. All right. You're Mr. Killingsworth here, 242159 at State Jail felony up there. What are we doing?
Of the first.
What are we doing?
Of the first.
I'll set it for trial.
Well, I think-
We got to move forward. I got a trial to get into.
Just,
Y'all just standing around and.
I think he had other cases pending indictments and second. So, that correct?
Australian?
It is my understanding that there are another case or other cases coming, Judge, but it's also my understanding that defendant's going to want a trial on these anyway, so we can put it on the trial docket.
What are we doing? It's an amendment. You can just tell me.
This is kind of.
Willie Thomas. What are we doing on this one? All right. When can y'all be ready on this first degree felony of aggravated robbery? That's what we're going to try first.
Yes, sir. A couple weeks, I can be ready, 2 or 3 weeks.
Okay. So we're going to go to trial. Put this on trial in 4 weeks, please. Thank you. Charles Dumas. Are you Charles Dumas?
Yes, sir.
Scott Rennick is your attorney? Where is he? Well, yeah. Well, it's.
You can leave that up there.
All right. Who's the state? The state's attorney is on this one. Is who? Charles Dumas.
That's mine, Judge.
Yeah, we're going to do this motion to revoke unadjudicated probation, and we're going to get this as quick as we can.
Yes, sir.
Yeah, they've got a new indictment on the criminal mischief, which is
Yes, sir, that's-
the allegation.
Judge, the deal on that is he's paying restitution. We've already worked out a deal with Mr. Rennick. He's paying restitution. This was a company truck that's, so
Mr. Rennick's not here.
we're going to, I know, Judge, we're going to dismiss the new case if he pays restitution. He's been working on, he's already paid half of it, and he's got another half to pay. And we were just going to do this week to kind of check up and see where he was on gathering the money.
Okay. All right. So
this will go
do we
away.
need to wait on Scott Rennick to get here as attorney, or can we just reset this?
We just need to reset it because he's still gathering money.
Till when?
Probably another 6 weeks, kind of see where he's at with the
I don't
money.
know. Where are you on it? On the money?
I need a little time.
Yeah.
Jobs around up for January.
So, well, how much money is it that you have to pay?
He paid 12,000 and he owes 8,000 more.
You have 8,000?
Yes, sir.
You paid 12?
Yes, sir.
This is where the tone of the courtroom shifts dramatically. These are not minor offenses. These are second-degree felony charges involving indecency with a child, carrying potential sentences of up to 20 years each. The judge methodically explains the rights being waived. No jury trial, no appeal, no second chances. This isn't just paperwork. This is a life-altering decision. When the defendant pleads guilty, the court ensures the plea is voluntary, informed, and supported by evidence beyond a reasonable doubt. And here's something many people miss. Even with a sentencing cap, the judge still holds enormous discretion. So ask yourself, is a 10-year cap justice, mercy, or strategy?
When do you think that 8,000 is going to be given? When do you think?
Mr. Rennick is here, Judge.
When do you think? You think 6 weeks?
Sure.
All right, I'll reset it 6 weeks, okay? Do the resetting there, thank you. Devontae, Gilbert.
He's here, Judge.
Okay, you ready?
What we've witnessed today is the full spectrum of the justice system at work, from bond debates and delayed forensic evidence, to guilty pleas in serious felony cases, and judges pushing cases forward instead of letting them stall. The court balanced discretion with accountability, emphasizing that probation is a privilege, not a right. In cases involving public safety, children, and repeat concerns, the margin for error disappears fast. Every ruling today carried long-term consequences, not just for defendants, but for victims and the community as a whole. Now we want to hear from you. Do you think the court struck the right balance here, or should stricter lines be drawn earlier? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.